All rise, please. United States District Court is now in session. The Honorable James L. Robart, United States District Judge presiding.
Please be seated. Clerk will call this matter.
Case C-12-1282, United States of America versus City of Seattle. Counsel, please make your appearance.
Michael Diaz for the United States, Your Honor.
Michelle Young for the United States, Your Honor.
Thank you.
Greg Narver for the City of Seattle, Your Honor.
Sarah Moorhead for the City of Seattle.
Peter Holmes for the City of Seattle, Your Honor.
Thank you.
Merrick Bob, Monitor.
Thank you. Counsel, under the terms of the settlement agreement in this matter, there are to be periodic reports filed, and in addition to that, I have asked you all to be aware of the fact that I would periodically ask for status conferences. Sometimes there will be an administrative matter that we need to attend to, sometimes simply to let me know what's gone on in the prior couple of months. Today is one of those days where we are doing both. The administrative matter that we need to take up is the filing of the monitoring plan for the first year of the settlement agreement, a document which has now been consented to by the United States and also by the City of Seattle. And therefore, after I hear your comments, I'm at least inclined at this time to indicate that it's likely that I will be approving it. And secondly, to simply ask everyone to step forward and give me the benefit of their thinking as to what's happened the last couple of months and what will happen in the next couple of months. And as my agent for supervising the litigation, Mr. Bob, if you please go first.
Thank you, Your Honor, and thank you for hearing us today. We come to you with a monitoring plan that has been agreed to by all the parties. That did not come about easily. There was serious and substantial negotiation of the document, which I will describe later. In the last couple of months since we have been before Your Honor, we have, the monitoring team, made a number of visits to Seattle. 5 or 6 visits of 3 or 4 days apiece. Roughly, we've been up here every couple of weeks. And then, of course, we have our monitoring team on the ground here in Seattle, so that we have had a consistent, ongoing presence in the city, and we have done a number of things. First, we have acquainted ourselves and gotten to know the Seattle Police Department, the agency, of course, that is most affected by the settlement agreement. We've met on a number of occasions with the chief, with the deputy chiefs and assistant chiefs. We have met with people at each of the 5 precincts. We've met 4 of the precinct captains, 5 of the operations lieutenants. We have gone along to roll calls and appeared before the rank and file officers on several occasions. We have done a number of ride-alongs. We have met on a couple of occasions with the unions that represent the rank and file and the supervisors. We have enjoyed very good access to the Seattle Police Department. We've been given key cards. We can come and go as we desire. The Seattle Police Department has arranged for us to be trained on their computers and the databases that they use, although we have not had yet, although I think it'll come, the full access to a number of complaint files and a few other things. I think we've done quite well in terms of establishing a good mode of dealing with the department. We have gotten to know and appeared now twice before the City Council and responded to their concerns. There was a hearing yesterday, as a matter of fact, before City Council. We have met with community groups and organizations and individuals from the varied and diverse communities here in Seattle. We have met approximately 100 such organizations and individuals and attempted to get a sense for the varying perspectives on the Seattle Police Department. We have reviewed a number of documents. We have attended the sessions of the Seattle Police Department's Firearms Review Board and their Use of Force Review Board. We've had the opportunity to observe and indeed to participate in a number of those hearings, and have had a chance to see how the Seattle Police Department is proceeding there, and we think they're doing a good job. We have had many meetings and discussions with the parties to the case, with DOJ, with Peter Holmes and his staff representing the city. We've also had dealings with two compliance coordinators in the SPD, Steve Brown and now Bob Scales. We have met with the mayor on a couple of occasions and have met with some frequency with the mayor's council, and have, I think, begun in earnest to take the lessons from all those meetings and put them into the monitoring plan, which I'd like to now turn to. I would also like to point out that the monitoring plan has three major goals as set forth in the settlement agreement. One is to establish deadlines for the development of policies and training as required by the settlement agreement, and followed by implementation of those policies and the training. The second purpose of the monitoring plan is to adopt the outcome measurements and assessments agreed upon by the city and DOJ in the settlement agreement, and create a process to determine whether additional outcome assessments and measurements are appropriate. And third, to set forth the schedule for issuing compliance reports. This monitoring plan, Your Honor, does all that. I would like, with Your Honor's indulgence, to ask three people briefly to address you from the monitoring team. They are Peter Ehrlichman, who's the deputy monitor, Ronald Ward, who is the assistant monitor, and Pat Gannon, Chief Pat Gannon, formerly deputy chief of the Los Angeles Police Department and now chief of the Los Angeles Airport Police, who was a key figure in the implementation of the consent decree in Los Angeles.
That would be fine.
Peter?
May it please the court. My name is Peter Ehrlichman, and we've appeared before you before in the capacity as deputy monitor. Appreciate the opportunity to speak just briefly about that which I think the court is already well versed with, and that is, what are some indicators of success that might be derived from reviewing the settlement agreement, the memorandum of understanding, and ultimately the monitoring plan. There are some concrete examples that I'll touch on, but I will save my volume and emotion for the last indicator of success. Some of the early indicators of success might include an analysis of SPD's span of control to ensure that there are adequate number of qualified, full-time, frontline supervisors to provide the necessary mentoring and oversight of officers, and to eliminate the extended use of acting sergeants without sufficient training. Some of us have observed the use of acting sergeants in various precincts and can attest firsthand of the difficulty of fulfilling a sergeant's role that these men and women of the force have, where they are being asked to be both a supervisor and also a fellow squad member. And then, of course, there's the inherent lack of training that goes with that acting role. And I think you'll find throughout the settlement agreement and then universally throughout the discussions with the parties that everyone agrees this is an important component and another indicator of success of the consent agreement. Another indicator would be whether or not there are adequate numbers of persons trained in crisis intervention to ensure that CI-trained officers are available on all shifts to respond to incidents or calls involving individuals known or suspected to have mental illness, substance abuse, or to be in a behavioral or emotional crisis. And it's been the pronouncement of the SPD and the mayor to, by the end of this year, have all officers trained, CI trained. And that will be another indicator of success of this consent agreement. Another example might be whether or not all use of force is reported as required by the settlement agreement, tracked and properly classified, and thoroughly and objectively investigated and reviewed. And we'll be looking not only to those officers who report use of force, but also whether or not there are patterns of officers who are not reporting use of force, and try to understand why that is. But as I say, these are important but not the critical indicator of success of our first year and indeed of the plan itself. We view that the receptivity of the plan and the implementation of the policy changes that are represented in the consent decree and the receptivity of that within the community of the City of Seattle will be the greatest indicator of success. And we know this from looking at those consent agreements, those plans of monitors that have been successful in other cities around our country, that the greatest indicator of success, the greatest achievement of such an arrangement will be represented by the receptivity of the community. And my colleague Ron Ward will speak more to that very important topic.
Thank you.
Thank you.
Mr. Ward.
Good afternoon, Your Honor. Your Honor, I'm going to briefly address the Community Police Commission, which I'll refer to hereafter as a CPC in the interest of brevity. As the Court is aware, the CPC was an outgrowth of the settlement agreement and the memorandum of understanding of the parties, and then derivatively an executive order of the mayor and an ordinance promulgated by the Seattle City Council. The role of the Community Police Commission is projected in terms of four major facets. The first is consultation on whether new standards of data collection should be developed in order to facilitate this process effectively. The second is to review and make recommendations on policies and training regarding stops and detentions and bias-free policing. The third is review of the structure of the Office of Professional Accountability System and the roles of the Office of Professional Accountability Director, the OPA Auditor, and the OPA Review Board. The fourth is assessment of the Seattle Police Department's community engagement efforts. And in that regard, and in that context, I'd like to offer the following. The Community Police Commission is the on-the-ground representative of the people in the communities in this city. My personal hope is that it is an assertive representative, because without assertiveness on the part of that body, I don't think we're going to get the real change. I believe that that this body, the CPC, and the outreach that we're able to do is the transcendent, ultimate determinant of the success or the failure of this entire effort. We could, and we expect to have, an effective consent decree, but it could be perfect and we could still fail. That consent decree must be a foundation for the forging of a new relationship between the Seattle Police Department and the citizens of this city of Seattle. That new relationship cannot, and if the monitoring team and its efforts have anything to do with it, will not be a dynamic in which we've got demonization of the police and canonization of the citizenry, or vice versa. It has to be based on collaboration, on mutual dignity and respect, and on effective community policing. And no one has more to gain from effective community policing than the community and the people who they employ to serve and protect them. As Mr. Bob has stated, to date we have met with over 100 individuals and community organizations. That process will continue. Tomorrow morning at 10 o'clock, we've invited a broad spectrum of community organizations and individuals to Mr. Ehrlichman's law firm. He's kindly assented to hosting that. On Saturday morning, Mr. Eon Warner of Mr. Ehrlichman's law firm and I will be presenting to the Lauren Miller Bar Association, the statewide Black Association of Lawyers, and we have a busy schedule indeed planned thenceforth. I like to style myself a boundless optimist and a brutal pragmatist, and at this point, my boundless optimism is predominating. Does the court have any questions?
No, but thank you, sir. Gannon?
Chief Cannon.
Good afternoon, sir. My name is Pat Gannon. As Mr. Bob indicated, I'm retired from the Los Angeles Police Department after 34 years, and I was a deputy chief in charge of what was referred to as Operation South Bureau. I had 800,000 community members who lived in our service area, and it was predominantly communities of color. In early 2000, or late 2000, early 2001, the city of Los Angeles entered into a consent decree. And as a police captain at that particular time, I can remember how difficult that was, as not only personally but professionally, to enter into an agreement where people were referring to you as having a pattern and practice of bias policing, unconstitutional policing. And as somebody who had put their career trying not to do that, that was a tough pill to swallow. Part of the responsibility that I have as part of this mentoring team is to try and help the City of Seattle and the Seattle Police Department specifically to not go through the same trials and tribulations that we went through in Los Angeles, waiting to try to accept the terms or to determine to fight it for so long until we actually put our nose to the grindstone and got to work and did something productive. Instead of taking 9 years, almost 10 years for the Los Angeles Police Department to come into compliance, it'd be our hope and part of my responsibility to help the Seattle Police Department go much faster. Mr. Bob has asked me, or asked as part of our review, to review the monitoring plan. And as part of my review of the monitoring plan, it is very similar to what the plan was in Los Angeles. Not much deviation at all. There's a few additions as part of the settlement agreement that was not in Los Angeles, but as a whole, it is very, very similar. I think that the expectations of the monitor are very high, but I think that they're fair also. The outcomes, I think, in the compliance with this monitoring plan, just like it did in Los Angeles, where it made us a better police department. In fact, I was talking to a colleague this morning in Los Angeles and explained to them that I was up here and I was going to be in federal court. And they indicated also, another deputy chief, that they thought the same way that I did, that actually the consent decree was the best thing that ever happened to the Los Angeles Police Department. And as Ron indicated, not so much for the boxes that were checked, but the way in which the community came around and the police department came around and forged new and better relationships. And though they can always be better, it was a huge difference in Los Angeles, and I truly believe it could be a difference here in Seattle. Thank you.
In your experience in Los Angeles, what were the first indications that you were getting community acceptance of the changes?
Well, there were a lot of different issues, but I think at some point we brought in a new police chief, actually, Bill Bratton, that came in from New York. He made it his first year, as there was only 3 goals in the Los Angeles Police Department. 1, we were going to keep the city free of terrorism. 2, we were going to reduce crime. And 3, we were going to have complete implementation of the consent decree. Those were his 3 goals, and they remained his goals for 7 long years. And he talked about that each
I
every
go
day.
senior in 2016, so
But I think it doesn't happen overnight, sir, and it really doesn't happen by chance. It takes a lot of hard work, and it takes a lot of hard work by people within the police department to change the way that they think about different things, and the way that they think about the community, and the way in which they interact with the community. The community has what I used to always say is they have a long memory on bad things and a short memory on good things. And so you have a lot to overcome in order to continually move forward. But if you're always working towards that, you can. In the LAPD, we brought in some of our biggest detractors to be our partners in this. And I don't want to call Miss Connie Rice the detractor, but she sued the living daylights out of us for a long time. And she became, she agreed to come in and to work hand in hand with us and became a true partner. Not always our best advocate in that sense, but an honest advocate for what was going on. That played a big role. Mr. John Mack, who was the president of an urban league in Los Angeles, became the president of the police commission. Very fair man who had high expectations. Those kind of leaders that came forward in Los Angeles to help change the tide, in addition to constitutional policing.
all right, thank you. Mr. Ward, when you next come back to court, I'd welcome your observations as to the progress we're making with the community at that time.
I'm sorry, Your Honor, would you repeat that?
Yes, when you come back next time, I would welcome your observations on the progress that we're making. It seems to me that that's something that you're going to be uniquely able, because of your continued association and outreach, to help the court with.
Thank you, Your Honor. I'll welcome the opportunity to give that.
All right. Mr. Bob, anything further, sir?
I think we're ready to talk a bit about the monitoring plan.
All right.
I think the thing I'd like to emphasize is that this monitoring plan is a collaborative effort. It is not just the monitor, but the parties themselves contributed substantially to the monitoring plan. Although it was not required of us, we gave a draft of the monitoring plan to the parties for their review on February 1. And the city provided written and oral comments thereafter. We sat down for 3 days straight with the chief of police, counsel for the mayor, counsel for the city, and others to work out and discuss the problems that were perceived and tried to come up with language and tried to come up with a solution that would be a collaborative effort and satisfy all. I think that we succeeded in that regard. Obviously, there were some rough seas to cross last week and so forth, but the ship has arrived safely at shore. And we have a monitoring plan that establishes the priority. Obviously, the priorities of the plan are with respect to use of force and dealing with the risk of police misconduct and constitutional conduct around use of force issues, and also around discriminatory policing issues. The indicators that are in that document stretch beyond a year, at least in terms of the way we envision success. And Peter Ehrlichman, I think, very ably summed that up, as did Ron Ward. This will be a success. This monitoring plan will be a success, and the settlement agreement will be a success when there is a difference in attitude on the part of the Seattle Police Department with respect to the communities, the varied and diverse communities it serves, and a change in perspective on the part of communities that have, in particular, felt themselves aggrieved by the Seattle Police Department. And as Pat Gannon was able to achieve in Los Angeles, in the South Bureau, so too I hope we will achieve here, and that is that the community and the department will find themselves in far better a place working collaboratively to solve the problems of crime on the streets of Seattle. With that, Your Honor, I would submit the monitoring plan and let the parties speak to it.
All right. Thank you, Mr. Brown. Mr. Diaz, who's speaking for the government today? Ms. Leung?
Good afternoon, Your Honor. My name is Michelle Leung, and I'm with the Civil Rights Division of the Department of Justice in Washington, D.C. And if it pleases the Court, I was planning on briefly talking about why the United States, as indicated in our filing on March 6, approves the monitoring plan submitted by Mr. Bob.
That's fine.
The document submitted by Mr. Bob, as he indicated, really was the product of a lot of input and negotiation, and we believe it reflects the concerns expressed by both parties. Importantly, we also think that the document neither expands nor contracts the requirements of the settlement agreement. Specifically, we think that the monitoring plan satisfies the requirements laid out in paragraph 183 of the settlement agreement because it both identifies the requirements of the agreement that will be assessed and because it identifies deadlines for policy and training review in the first year. These clear deadlines will help prevent unnecessary delays, establish realistic expectations for the parties, and will ensure efficient implementation of the settlement agreement. We also think that this document gives the community an understanding of the monitor's activities It gives the parties both certainty and flexibility, and it gives the SPD guidance on the monitoring team's expectations in this first year. Finally, we're pleased that the monitoring plan formalizes a collaborative approach that requires the monitor and both parties to work together to make sure that the reforms are implemented correctly and most efficiently. In short, we believe that the monitoring plan gives all the stakeholders in this process an understanding of what the monitor is up to for the first year and what success will really look like. Thank you, Your Honor.
Thank you. Mr. Holmes, who's speaking for the city? Mr. Narver?
I will be, Your Honor. May it please the Court. Again, I'm Greg Narver, Assistant City Attorney for the City of Seattle. Before I address the monitoring plan, I would like to quickly make an introduction to the Court. At the first status conference, you were introduced to Steve Brown, who was at that point the Seattle Police Department Compliance Coordinator. Mr. Brown has since retired, and his replacement is Bob Scales, who is in court today, so you have a face to go with the name.
Welcome, Mr. Scales.
Mr. Scales has been the compliance coordinator for a couple of months, and he has been hard at work that whole time in implementing the provisions of the settlement agreement. As the Court is aware from the notice that we filed last week, the City of Seattle has approved the monitoring plan for the first year. Mr. Bob referred to some rough seas that we went through. I think that's a reflection of the fact that the issues of reform and implementation of the settlement agreement are extremely important issues about which every elected official in the city and every member of the Seattle Police Department feels very strongly about.
I'm concerned that his analogy to a crossing of the rough seas, but the ship has arrived safely, is reminiscent of a Walt Whitman poem in which the captain lies bloody heap on the deck. That didn't seem like a good start to me.
Oh, gosh. Can I go with "Oh Captain, My Captain" instead, and maybe that's a little more elevated? I'd like the focus to be on the fact that the ship has arrived, and I don't think anyone's particularly bloodied. What people have done is express some strong opinions about the fact, for example, as Mr. Bob said, the first draft of the monitoring plan had some aspects in it that were objectionable to the city, and there were very lengthy and productive and substantive negotiations that have brought us to the point where we are today, where the city can say, there were changes made to the plan, and we are here today able to say that, yes, we approve the monitoring plan. A second aspect that's helped bring us here today is reflected in our filing, and that's the fact that this is a living document, and that's something that's reflected in the monitoring plan itself. The plan notes, for example, on page 3, Mr. Bob notes there correctly that the implementation of a settlement agreement of this complexity is a dynamic process, and as Mr. Bob stated, he anticipates that the monitoring plan may need to be supplemented and amended from time to time. Page 12 of the monitoring plan refers to the appendix that sets out the detailed timetable for implementation of the various tasks related to the settlement agreement. That's referred to also as a living document that by necessity will change over time. There have been direct communications between the city and the monitor, including involving the mayor himself, about this fact that this is a living document, that the monitor has indicated he's opening to hearing concerns of the city and working on a collaborative process and, if necessary, amending the agreement. The monitoring plan, for example, states that it doesn't expand or contract the settlement agreement, and if in the future the city does have concerns about that or objections, we're going to raise them with the monitor and hopefully continue to work in the same collaborative nature that we have been over the last couple of weeks and try to work out those differences. So that's the second thing. The concept of the plan is a living document, and the openness of all parties to engaging in continuing a collaborative process, that's another critical point that allows us to be here today and say that we approve the first-year plan. The last point I'd like to make is that no one should get the impression that the agreement to the monitoring plan is just the beginning of reform. It is one more step forward in a process that's been underway for several months. The monitor in his plan and today in court has listed a number of the steps that the Seattle Police Department has already been taking towards fulfilling the settlement agreement. SPD has delivered already some draft policies related to use of force, biased policing, stops and detentions, which are being reviewed. There's been a lot of access provided to the monitoring team, to the police department, training in the use of electronic databases. The city has worked hard on compiling its own internal schedule for the deadlines of reform. This is a process that everyone in the city is absolutely committed to. Chief Diaz is here today, and a number of the high-ranking officials in the police department who are working hard on reform. We are absolutely committed to working together in collaboration with the department and with the monitor on continuing that and in working forward aggressively on compliance with the settlement agreement.
All right.
Thank you,
sir. The court has previously indicated its intention to sign the first-year monitoring plan, and I will do so and file my executed copy in the docket of the court. Let me address some comments to the presentations that were made here today, starting with the positive. Mr. Bob and I have an opportunity to converse regularly. I don't see as much of Mr. Ehrlichman and Mr. Ward and Mr. Gagnon, but I appreciate your comments, and I very much appreciate your hard work on this. And Ms. Leung and Mr. Narver, as advocates for parties to the litigation, your efforts are essential. I would also affirmatively acknowledge that there have been some significant milestones in this, and I would go back to the entry of the Memorandum of Understanding and the settlement agreement, the appointment of a monitor, an issue that in and of itself was not without controversy, the establishment of the Community Policing Commission, which I share the belief it can have a transformative effect in opening a line of communication between the police department and the various communities that constitute the city of Seattle. And now the acceptance of the monitoring plan for the first year. I consider all of those to be significant milestones that we would not have accomplished but for the hard work of the people who are here. Before I proceed in my comments, I would like to remind people of why we're here, which I find meaningfully is stated in the first paragraph of the Memorandum of Understanding and is repeated in the settlement agreement, where it states the United States and the City of Seattle, collectively the parties, enter into this Memorandum of Understanding with the goal of ensuring that police services are delivered to the people of Seattle in a manner that fully complies with the Constitution and the laws of the United States. That's one goal. Effectively ensures officer and public safety, something that this court sees frequently and worries about a lot. And lastly, promotes public confidence in the Seattle Police Department and the services that it delivers. Those are three lofty goals and form the controlling emphasis of this court in its efforts to administer the settlement agreement. Having said that, the recent weeks have seen a breakdown in our concentrated attention to these issues by what the court charitably refers to as distractions. And I'm going to talk about three of those distractions and then close this hearing. First, a disclaimer. Some of my remarks are based on press and media reports, so they're not based on first-hand knowledge. I must say, however, given the availability of internal documents to news sources, I'm relatively confident in these reports. That's not particularly meant as a compliment. I picked 3 of them that are of concern to me. One, the quote that the litigation process ended once the settlement with the Department of Justice was reached. That's simply wrong. This litigation is brought by the Department of Justice under the Violent Crime Control and Law Enforcement Act of 1994. It's not necessary under that act that a settlement be entered in the form of a consent decree. However, the parties in this instance executed a memorandum of understanding and a settlement agreement. The parties obligate themselves in that settlement agreement to have the settlement agreement entered as an order of the United States District Court for the Western District of Washington. Let there be no doubt then that what you have is an order of this court. It is not a private contract between the parties. It is an order of this court, and it is subject to the jurisdiction of the federal judiciary. The language in that agreement goes on to say that once the parties have entered into that settlement agreement, the role of the court frankly begins and does not end. The court retains jurisdiction for all purposes, including but not limited to disputed changes to policies, procedures, training, and practices until such time as the court determines that the city has achieved full and effective compliance with the settlement agreement and has maintained such compliance for not less than 2 years. The agreement goes on to further say that the court has the power, sui sponte, to issue orders or directions to the parties and/or monitor regarding the settlement agreement, including but not limited to the construction, performance, and enforcement of its terms and provisions, as well as punishment for any violations or lack of compliance. I have given not final approval to the settlement agreement, but preliminary approval. And I've said that I will not enter final approval until the parties have reached full and effective compliance. And to me, full and effective compliance ties back to those 3 goals that we started off with. So, for better or worse, you have me for a while. And the litigation is not ending, it's beginning. Second is something, and I want to be very careful to use your language and not mine. The city, in its acknowledgement, and the mayor in his remarks, has made an important point, namely that the monitoring plan is not a static document, but a living document that can be amended. And the court agrees with that. In fact, there is a provision in the plan for how amendments occur. I want, however, to make clear that the provisions of the settlement agreement are clear as to how those amendments take place, which is that it needs to be amended with court approval. That fact is memorialized in the settlement agreement, wherein paragraph 174 states, "The parties and the monitor may jointly stipulate to make changes, modification, and amendments to the settlement agreement and will submit the stipulation to the court for approval." I applaud the fact that you work to resolve these issues together. You really would not be very excited to hear my vision of what would have happened had you not agreed to a monitoring plan, because what would have happened would have been you would have been out of compliance with the settlement agreement by 1 month, and the court would have been free to enter its own version of the settlement agreement, something that I suspect none of you, including me, would have liked or wanted to do. But in terms of the belief that the settlement agreement can be changed by the simple agreement of the parties is not correct, and I don't wish to have any misunderstanding as to that fact. Lastly, and in a very recent development, the court was made aware yesterday that a lawsuit was filed by the Seattle Police Officers Guild and the Seattle Police Management Association. It was not filed in this court, it was filed in state court. And it, among other things, states that it seeks an injunction permanently enjoining defendants from implementing any changes in the wages, hours, and working conditions of the employees represented by plaintiffs until they have discharged their bargaining obligations required by RCW 41.56. Named as defendants in that are the City of Seattle and Mr. Bob, who is the court-appointed monitor described in the settlement agreement as the agent of the court. I'm not aware of any jurisprudence which allows a state court to tell me what to do in my settlement agreement. But we will await with interest the ruling of the state court. There is lots of jurisprudence on that subject, which the various lawyers in this room would be happy to take up with you. The two groups went out of their way to say that they welcome change, that they're not attempting to be obstructionist. I can only tell you that having read the litigation, it says that something may arise in the future, and they apparently want it resolved in state court before that happens. I view that as a further distraction from the purpose for which we are assembled here today. The collective bargaining rights guaranteed by state law should be respected. On the other hand, the notion that the collective bargaining rights are going to control what happens here is simply not a legally supportable proposition and isn't going to serve anyone who have any interest in this matter. So there are three things that I wanted you to know. That this court takes its obligation of supervising this settlement agreement seriously. It appreciates the hard work of the people who are before the rail here. It appreciates that there's much to be done. The settlement agreement provides that once full compliance is achieved, a 2-year period of full compliance is required before I can quietly go into that good night. So go out there and work hard on getting that done. Council, is there anything further that the parties wish to discuss today?
I don't believe so, Your Honor. Thank you.
Mr. Bob, anything on behalf of the monitor?
Nothing further, Your Honor.
Then we will be in recess. Thank you.
Thank you.
All rise, please. Court is in recess.